So yeah, basically where we're at with the situation involving my truck, y'all, that I've been telling you that was taken by Dakota Crimmings, Lieutenant Mike Ingalls, and Zachary Overton of the South Bend Police Department when they came on my property. It was all initiated by Dakota Crimmings, but these other two officers got involved as well. So, like I said, the city of South Bend, y'all, is requesting 10 months. That's what they trying to request from the judge, in which I'm like, that's entirely too long to request for discovery in which the police report already shows what took place. So what discovery are you possibly gonna discover in 10 more months of litigation? And that's basically what I put in my response, because I had to create a status report, because that's what that letter was from the judge. If you go watch the other video, I'll let you know that Scott Frankel said that we needed to put in a status report, and this is my affidavit that I created. I already sent it off to the court, but I wanted to read some of it to y'all so you guys could check out what I put in my status report in regards to them requesting 10 months of litigation. 10 months of discovery. And this is the city of South Bend. The attorneys that's basically requesting this. And for my viewers, once again, this was a state court complaint, and I had it removed to federal court. You see what I'm saying? So I had to go through some steps and paperwork to get to this point. So, to all my viewers out there, if you don't have the brain capacity or just the patience to intake all of this, you might want to hire an attorney. But okay, so yeah, this is what I basically came up with. After I put my little draft together, I put complainant Mackenzie Pro Se submits the status report pursuant to the court's order of December 11, 2025, y'all. Defendant's proposal to delay settlement for 10 months demonstrates bad faith. If they were genuinely interested in resolving this matter, they would engage now. Instead, they seek to use the cost and burden of protracted discovery as leverage against a pro se litigant. This is precisely the type of gamemanship this court should condemn. This is not a traffic dispute. This is a constitutional siege. On January 28, 2023, while I had an active appeal challenging police perjury pending, South Bend Police executed a warrantless retaliatory seizure of my property from the sanctuary of my home, y'all. Their own report admits no warrant, noticing an expired license plate only, immediate declaration that my property didn't belong to me before asking my name. Then all video evidence destroyed, vehicle destroyed, now procedural games. I will not negotiate my constitutional rights. I will not beg for what is mine. I will not settle for less than the value of the freedom they attempted to steal. This court now decides, will it be complicit in lawlessness or enforce the Constitution? 1. Nature of the case and undisputed facts, y'all. This is a 1983 action for Fourth Amendment violation, warrantless seizure from home curtilage. Y'all might want to go check that out, because I know a lot of y'all have had warrantless seizures from home curtilage. Go check that case out right there. Fifth Amendment violation, uncompensated taking of property, municipal liability, city's custom of evidence destruction. Undisputed facts from defendant's records. Vehicle seized from 802 East Bowman Street driveway on 1/28/2023. No warrant obtained. Stated basis, expired license plate. City admits destroying all video evidence. The vehicle was destroyed post-seizure. Officer Crimmings 2336 stated upon contact it was showing that the vehicle didn't belong to me before obtaining identification on who I was, y'all. Without even identifying you, or how would you be able to assert that? That's a good one. 2. Service. All parties served and appeared. 3. Discovery. Defendant's 10-month delay is bad faith, y'all. Defendants proposed discovery until October 30th, 2026, which is 10 plus months. This is a deliberate obstruction because, one, no new facts exist, y'all. All evidence is in their police report and admissions. It's all their evidence that they wrote that we're using against them. Two, purpose is to increase settlement pressure on me, as well as creating a financial burden on me, the pro se complainant, y'all. 3, violates Rule 1's speedy resolution mandate because this case was filed March 5th, 2025, and they want to stretch it to 2026, 2027. 4, constitutional injury ongoing. I have been deprived of property for 772 days and still counting. And actually, I gotta rechange that because it's technically been 1,088 days, I think. So yeah, I'm gonna put in an update anyway on the price and the correct numbers that need to be produced because, like I said, this is an ongoing deprivation. It's never stopped. Targeted 60-day discovery. Now this is my request that I'm making for discovery because they want 10 months, which it shouldn't take that long. It only should take 60 to 90 days. Request for admission to crystallize undisputed facts, which I'm trying to get them to admit to something because they've been denying the whole fucking show. 2, document request. SBPD evidence destruction policy. Let's see that, evidence destruction policy because I want to see what are the requirements for destroying a motherfucker's property. Yeah, let's see that. And I'm also requesting insurance bond info for officers according to Indiana Code 5-4-1-18, y'all. And I want to see the vehicle destruction records. Who authorized my vehicle to be destroyed unlawfully? Let's see that. 3, deposition, 2 hours each from Officer Crimmings on his, the vehicle doesn't belong to you statement. I want to know, Officer Crimmings, how did you come up with that alternative or those accusations? How did you, let's hear that. I want to hear from Lieutenant Mike Ingalls for ignoring my ownership documents because I gave you my ID. I gave you the title to the car. I gave you the receipt where I purchased the car from, along with the insurance papers, and you balled them up, and you were so upset because I got my shit in order, Mike. I'm one of those, Mike. You don't know who you fucking with, Mike. And Officer Overton, you failed to intervene, young man. You stood there and you watched your fellow officers commit a fucking riot, a riotous and tumultuous act. Go look what that is. I'm just schooling y'all because this is the shit that y'all did. And I put complainant's deposition is unnecessary for liability determination because this is about 3 officers' conduct, not the real party in interest, which is me. So I have no reason to create a deposition. I'm the one that was woken up out of my fucking sleep and, had my family fucking terrorized. So yeah, get y'all shit in order. And we got amendments, none anticipated. Pending motions, acknowledging court's order, docket 31. I will refile summary judgment after discovery, y'all, because I put in a summary judgment motion before this paperwork was submitted, and that's the letter I was telling y'all about that Damon Arley, he sent me. He basically struck that filing because I was moving faster than the court. So that's the real basis of why he struck my filing because, they're just slow as fuck. And then he's like, oh yeah, pro se litigant is held to the same standards as a represented party or whatever, man. Dispositive motion deadline. Now the defendants, the city of South Bend, is proposing December 4th, 2026. I'm letting them know this is unacceptable because constitutional violations worsen daily. Each day a deprivation compounds damages, y'all. Evidence destruction admitted. The city sent me a letter saying that the body cam and dash cam footage of the entire event is no longer. So no discovery needed for destroyed evidence by the city of South Bend themselves. What discovery could we possibly come up with, y'all? You see the type of, this is the type of things that we're attacking. Calculated observation, 10 months to answer simple and already admitted police report questions. That's basically what they need. They need 10 months to answer the shit that they already reported.